A unanimous Supreme Court decision just slammed the brakes on one of the most dangerous shortcuts police were using around guns in private homes. Pause. And if you carry, store, or even talk about a firearm in your own house, this matters to you more than most people realize. Quick question before we continue. Are you subscribed yet? Because most gun owners hear about court decisions way too late, after the damage is already done. If you want clear updates without the legal mumbo-jumbo, hit that subscribe button right now, and let's get into it. Here's what just happened. The case is Caniglia versus Strom. The vote was 9-0. Every justice agreed on the main point. Police do not get some wide, open-ended excuse to enter your home and seize your guns just because they say they are doing community caretaking. That phrase sounds harmless. It sounds helpful. But that was the problem. It was vague. And vague rules are dangerous when your rights are on the line. Let me break this down for you. Edward Caniglia got into an argument with his wife in Rhode Island. During that argument, he put a handgun on the table and made a disturbing comment. His wife left and stayed at a hotel. The next morning, she could not reach him, so she called police for a welfare check. Officers showed up, talked to him, and got him to go to the hospital for a mental health evaluation. According to Caniglia, he agreed to go only after officers said they would not take his guns. But once he was gone, officers went into the home and seized his firearms anyway. Now pause right there. Imagine this happens to you. Maybe you said something stupid in anger. Maybe your spouse overreacted. Maybe a neighbor heard yelling. Maybe you are not under arrest. Maybe no judge signed a warrant. Maybe you even cooperated. Then suddenly your home is entered and your guns are gone. That is why this case matters. The lower court had sided with the police. It basically said officers have lots of non-criminal duties in real life, so maybe they can enter a home without a warrant when they think they're helping. That idea came from an older case about cars, not houses, and that's the part most people miss. The older case, Katie v. Dombrowski, dealt with an impounded vehicle, not a private home, not your bedroom, not your gun safe, not your kitchen table. The Supreme Court said lower courts stretched that idea way too far. And this is the line that really matters. What is reasonable for vehicles is different from what is reasonable for homes. In plain English, your car gets less privacy protection than your house. Your home gets the highest protection. That does not mean police can never enter without a warrant. It means they cannot use some loose catch-all label to do it. This is where it gets personal for gun owners. Most people think the Second Amendment is the whole fight. They think if the law says you can own or carry a gun, that is the end of it. But the truth is more complicated. Your gun rights and your privacy rights work together. One protects your right to have the firearm. The other helps protect the place where that firearm is kept. If the government can walk into your home too easily, your gun rights become a lot weaker in real life. That is why I say this case touches both carry rights and privacy expectations, even though it is really a Fourth Amendment case at its core. Because where does your carry gun usually start and end the day? In your home. Where is your spare mag, your safe, your holster drawer, your paperwork, your training gear? Usually in your home. If that space is not protected, a lot of your practical freedom is not protected either. But here's the crazy part. This was a 9-0 decision. In today's Supreme Court, 9 justices agreeing on anything big is rare. So when you see that kind of unity, pay attention. The court was sending a message. A house is different. A welfare check is not a magic key. And we were just trying to help is not an automatic pass around the Fourth Amendment. Now, before you get too comfortable, there's something even more important. This case did not say police can never come in without a warrant. Do not make that mistake. The court did not erase emergency exceptions. It did not erase consent. It did not erase true urgent danger. If officers have a real emergency, that is a different fight. If you invite them in, that is a different fight. If they have a valid warrant, that is a different fight. And that is where a lot of people get burned. They hear a big Supreme Court case and think, great, now police can never enter my house without a warrant. No, that is not what Caniglia says. What it says is narrower, but still powerful. There is no standalone community caretaking exception for homes. In other words, police cannot treat your house like a disabled car on the side of the road. If you're finding this helpful, imagine what you'll learn in my next video about the exact mistakes gun owners make during police contact that cost them their rights. Subscribe now so you don't miss it, because staying legal is a lot easier than fixing a bad situation later. Now let me explain why this matters even more than it first appears. The court did not just protect one man in Rhode Island. It shut down a legal shortcut that could have spread all over the country. Think about how often police do wellness checks. Think about how often families call because someone said something scary or drank too much or stopped answering the phone or had a bad night. These situations are emotional. They move fast. And when firearms are involved, officers often get even more cautious. That caution is understandable, but the Constitution still matters when emotions run high. Here's a hypothetical example to explain this. Let's say you and your wife have a loud argument. You cool off in the garage. She leaves and calls her sister. The sister panics and calls police. Officers arrive. You're upset, but calm. You step outside and talk. You deny being suicidal. You agree to go get checked out because you want to show you are fine. If there is no warrant, no consent, and no true emergency that fits an existing exception, officers do not get to say, well, we are just caretaking, and go hunting through your house for guns. That is a huge deal. Second, this case draws a bright line between a home and a vehicle. And if you carry in your car, you need to hear this carefully. Your car does not get the same privacy protection as your home. That is not new, but many people blur the two together. They assume if a court protects guns in the house, the same rule applies during a traffic stop. Not so fast. Vehicle law is different. Search law is different. Officer safety rules are different. So do not overread this case. In fact, here's what most people get wrong. They hear gun rights win and think every police encounter just changed overnight. Not true. What changed here was the government's ability to use one specific theory to justify warrantless entry into homes. That is strong protection. But it is not a free pass in every gun-related contact with police. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. There were also concurring opinions in this case, and they matter. Some justices basically said, yes, we agree the broad caretaking theory goes too far, but real emergency aid situations still exist. That means if officers reasonably believe someone inside needs immediate help, courts may still allow entry under a different rule. So again, don't make the mistake of thinking this case ended all warrantless home entries. It did not. It cut off one route, not every route. And this is the part that shocked me when I first read it. Even in a case that looked like a big win for privacy, the justices were already warning that future fights would continue over emergency aid, suicide calls, and red flag style laws. So the win is real, but the fight is not over. Why does that matter to you? Because rights are not usually lost in one giant moment. They get chipped away by exceptions, labels, and special circumstances. A court says cars are different. Then a lower court says maybe houses are similar. Then another court says maybe safety concerns are enough. Then suddenly a vague idea becomes normal. Caniglia pushed back on that. And if you care about carry rights after Bruin, this case fits into the bigger picture. Bruin, decided later, focused on public carry and said the government has to justify gun laws through text, history, and tradition. Caniglia came earlier and dealt with search law, not carry permits. But together they show something important. The court is watching both sides of the problem, not just whether you may have a gun, but also how far the government can go when guns are in the picture. That is why I tell people this. The Fourth Amendment can be the bodyguard of the Second. If your home is not secure, your gun rights are easier to invade. If the government can use broad excuses to enter first and ask questions later, then your rights exist mostly on paper. Have you ever wondered why some gun owners lose property even when they are never charged with a crime? This is one reason. Procedure matters. Warrants matter. Consent matters. Labels matter. If police or courts can frame a seizure as help instead of investigation, some people assume the Constitution becomes weaker. Caniglia says not so fast. Hey, a huge chunk of people watching right now are not subscribed. Don't be part of that group. Join the gun owners who stay ahead of these legal changes before they turn into expensive mistakes. Click subscribe and stay informed with me. Now let's talk about what you should actually take away from this in real life. First, know the difference between cooperation and consent. Those are not always the same thing. You can be polite without giving up your rights. You can step outside and talk without inviting officers into the house. You can comply with lawful commands without saying, sure, come on in and look around. That distinction matters a lot. Second, understand that words said in anger can trigger a chain reaction. In Caniglia, one heated comment turned into a welfare check, hospital trip, and gun seizure. So if you own guns, your words carry extra weight. Fair or not, that is reality. Don't make this mistake. Do not say dramatic, reckless things around firearms and then assume everyone will read your intent the way you meant it. Third, if police show up for a welfare check, stay calm. Do not escalate, do not lie, do not physically resist, but do understand what is happening. Ask simple questions. Am I being detained? Do you have a warrant? Am I required to go? Am I giving consent? Or are you ordering me? Those questions can matter later. Fourth, if guns are seized, get legal help fast. Timing matters. Paper trails matter. Statements matter. The difference between a temporary seizure and a long legal mess can come down to what happened in the first few hours. Fifth, and this is big, do not confuse internet confidence with actual legal safety. I see people online say things like, just tell the cops they need a warrant and slam the door. That is childish advice. Real life is not a comment section. If officers claim there is an emergency, the situation can get dangerous fast. Your goal is not to win an argument on the porch. Your goal is to stay safe, avoid extra charges, and preserve your rights for court. Let me give you one more hypothetical example. Say your elderly father lives alone and owns guns. A neighbor has not seen him in 2 days. Police knock, no answer. they hear him groaning inside. Can they enter? Very likely yes, because that looks like a real emergency aid situation. Caniglia would not stop that. That is why understanding the limits of the case is just as important as understanding the win. But wait, there's one more thing nobody talks about enough. This decision also sends a message to lower courts. Stop inventing broad new exceptions for the home. The home is still special under the Constitution. That matters whether you own guns or not. But if you do own guns, it matters twice, because firearms often become the reason the government claims it needs extra room to act. And that brings us back to the title. Did the Supreme Court change carry rights and privacy expectations? Yes, but not in the lazy, clickbait way some people mean it. It did not create a brand new national carry permit rule. It did something more basic and, in some ways, more important. It reinforced that the government cannot use a vague caretaking label to cross the line into your home and take guns without following the Constitution. Laws change fast, court cases move even faster, and the next big ruling can shift the ground under your feet overnight. Subscribe now so you stay ahead of the next update, because the people who learn this stuff late are usually the ones who pay the highest price. So here's the bottom line. Caniglia via Strom was a unanimous warning from the Supreme Court that your home is not just another place police can enter because they think they are helping. For gun owners, that matters, because your privacy rights help protect your gun rights in the real world, not just in theory. Pause. If this kind of straight, simple breakdown helps you, hit subscribe and stick with this channel. I spend the time digging through these cases so you can understand what actually changed and what did not. And one last thing. This video is for education only. It is not legal advice, and it cannot replace a lawyer who knows the facts of your case and the laws in your state.